Good afternoon. This is Molly Zimmerman, and I'm happy to welcome you today to Professor Shubha Ghosh, the Crandall Melvin Professor of Law and Director of the Technology Commercialization Law Program at Syracuse University College of Law. This webcast is brought to you through a grant from ESD NYSTAR, sponsored New York State Science and Technology Law Center. Thank you for being here, Professor Ghosh.
Thank you, Molly, and welcome back. Glad to have people attend and share with you some information regarding a case that's in front of the Supreme Court. And oral arguments are scheduled for this Monday, April 25th, so we're a little bit ahead of the schedule, but this will give you some background because it's a fairly complex case involving a very important development under the America Invents Act, inter partes review. So this is basically as an administrative procedure that allows people to challenge patents once they've been granted. So we'll talk about the facts of this case, the background to this case. The subtitle for today's presentation is Adjusting the Speed of the Patent Office with a question mark, and that's meant to be kind of a pun on the technology that's involved, which is a modified speedometer. But also about the way in which the Patent Office has been reviewing granted patents for their validity and the use of both inter partes review since the enactment of the AIA in 2011, and then more recently the use of post-grant reviews. So this case involves inter partes review, but we'll be talking about other administrative procedures as well. In fact, as I understand it, this is one of the first instances of the use of inter partes review, and this is of course the first time the Supreme Court is reviewing that procedure and the rules that underlie it. So this is a pretty important case. On Monday, the court is also hearing arguments in the Kirstang case versus Wiley, and if people remember, that was a copyright case from about 2 years ago involving international trade and exhaustion. Now the court is reviewing that issue on the question of attorney fee shifting in light of its Octane Fitness decision. So I won't talk about that, but it's a double header on Monday for those who are interested in IP. It's a very heavy day for both copyright and patent at the Supreme Court. We will have a couple of other podcasts over the summer, and we'll give you information about that later, but probably sometime after the Supreme Court term ends, we'll have another podcast where we will go over what exactly happened in the various cases that we've talked about, the Halo case from last March, and then the Cuozzo case, and then also Kirstang and other opinions. So look out for that. We'll send you some information. So what are we going to do today? The basically overview of the webinar for the next hour or so is to give you background to Cuozzo, and this is a lot of background here regarding both the AIA and inter partes review and post-grant review to give you some sense of the stakes in this case, and then we'll look at the arguments that are being raised that were raised both at the PTAB, the Patent Trial and Appellate Board, and the Federal Circuit, and then are likely to be raised in the Supreme Court on Monday. And then conclude by talking about some implications for practice and for technology commercialization. So Molly will be taking questions, so at any time feel free to type in your questions, and as appropriate we'll respond as soon as possible. So I'd like to make this, despite the format, as interactive as possible. So be ready with questions. I'm sure there'll be a lot because the first part is going to be fairly heavy in the law and some of the background to Cuozzo. So at issue in this case, as I mentioned, oral argument is on April 25th, this coming Monday, and there are two questions that the Supreme Court granted cert on. This case is on appeal from the Federal Circuit. And so the first question is whether the Court of Appeals erred in holding that in IPR proceedings, the board may construe claims in their broadest reasonable interpretation rather than their plain and ordinary meaning. So for those who are patent prosecutors will know that the broadest reasonable interpretation is the standard that the PTO uses for construing claims when they're being examined. And it also arises in other administrative proceedings, such as reexaminations and interferences. And so now the court is looking at whether this is the right approach to have in the context of IPR proceedings. And one of the things that's interesting about this question is the way they juxtapose the broadest reasonable interpretation with plain and ordinary meaning. You know, one obvious question here is if they basically do away with broadest reasonable interpretation, what's going to replace it? And if these are the two choices, then obviously if one is gone, that leaves plain and ordinary meaning. But if you go back and look at the Federal Circuit opinion and even the PTAB opinion, they use both. In fact, they talk both in terms of broadest reasonable interpretation and plain and ordinary meaning as guiding their interpretation. So it's not quite clear if this question, I mean, the question is pretty clear in terms of looking at broadest reasonable interpretation, not so clear as to what the alternative really is. And so I'll have some more words about that later. The second question has to do with whether the Court of Appeals erred in holding that even if the board exceeds its statutory authority in instituting an IPR proceeding, the board's decision on whether to institute an IPR proceeding is judicially reviewable. And so this is a very interesting question regarding the relationship between judicial review and the decision to institute an IPR proceeding. And so in a previous decision by the Federal Circuit ruled that there was no interlocutory appeal if the board either decided to grant an IPR proceeding or denied the IPR proceeding. And in the Cuozzo case, the Federal Circuit said there's also no appeal once there's a final decision. And so the issue then is whether this is consistent with the goals of the American Invents Act, as well as kind of the structure of the court and agency system that we have. So the second question is particularly striking because it does get into, as does the first one to a certain extent, but the relationship between the PTAB and the courts with respect to these new proceedings under the AIA. So let's go on to talk about some background before we look at these questions more closely. So inter partes review basically modeled on the reexamination proceedings, but very different under the AIA. They're laid out in 35 U.S.C. sections 311 to 319. And basically this allows someone other than the owner of the patent to challenge the validity of the patent. And one of the issues is that whoever is the person who's challenging the validity must identify any real parties of interest. Who exactly they may be representing. Is there someone who may be subject to an infringement lawsuit, someone who may be having some connection with the patent owner. This question of who the real parties of interest is probably something that will give rise maybe to some Supreme Court review in the future, but has also been one important dimension of this particular proceeding. And so this person, whoever this entity is, other than the owner of the patent, has the right under inter partes review to petition the USPTA to invalidate patent claims. And the basis for inter partes review has to be lack of novelty or non-obviousness based on prior art patents and publications. So invalidity is limited to two criteria, either novelty or non-obviousness. And also there's some limitation on what type of prior art can be used. So the limitations are to patents and publications. Under inter partes review, something like on a public use or on sale would not be appropriate prior art. And furthermore, things like 112 or 101 patentable subject matter would not be a basis for invalidity. So one of the aspects of the inter partes review is the timing. So these can be initiated either 9 months after the grant of a patent or after the termination of any post-grant review of the patent. So there is another proceeding that's worth talking about. It's not at issue in the Cuozzo case directly, but there is a lot of overlap between inter partes review and post-grant review. So just as a brief summary, once the patent is granted, as we'll see, a post-grant review can be initiated, and there's a deadline for that. If a post-grant review is initiated, then once that gets terminated, then there's the possibility of inter partes review. They cannot be duplicative, so it's not two bites at the apple. It's just basically two separate proceedings that allow the introduction of new type of prior art for the purposes of invalidity. So let me just talk briefly about post-grant review and some other aspects, just to give you a complete picture of what's at stake. So post-grant review is laid out in 35 U.S.C. sections 321 to 329. And again, this allows someone other than the owner of a patent, again, you must identify real parties of interest, to petition the USPTO to invalidate patent claims on grounds of invalidation under sections 282B2 or 3. So this would be the major grounds of invalidation: lack of subject matter, lack of utility, lack of novelty, lack of non-obviousness, or lack of specification or written description. And this has to be done within 9 months of the grant of a patent or a reissue. So we need to think about these two together as sort of a strategy, but the idea is that initially, either when the patent is first granted or when it's being reissued, there's a broad scope in which the patent can be challenged on validity grounds, broad use of prior art, and so forth. And then once that window closes, there's still a possibility to bring a challenge, but it can only be brought on novelty or non-obviousness grounds and on limited prior art, prior patents or publications through an inter partes review. So that's the structure we work with. The inter partes review went into effect in 2011. The post-grant review went into effect, it applies to patents issued after March 16th, 2013. Inter partes review is broader in terms of which types of patents can be challenged, though do keep in mind the 9-month window. And so many of you may be familiar with something that preceded the post-grant review. So there was a much narrower type of review that applied to covered business method patents that were the subject of litigation. And there's lots of challenges administratively to covered business method patents. I'll talk a little bit about them. I'll be glad to take any questions about them, but they no longer exist. This covered business method patent, narrow type of post-grant review has been replaced essentially, or has been superseded by this broader review that's laid out in 321 to 329. So that's basically the landscape, and it's useful to know a little bit about how the process is structured for both inter partes reviews and post-grant reviews. So there's a two-step process. The first step is whether the PTO will institute the proceeding once a petition has been filed. And this is decided by one administrative law judge within the PTAB. And the standard for this, for post-grant review, is whether it's more likely than not that the petitioner will be successful, or there's a novel or unsettled legal question that affects this patent as well as other patents. So it could be regarding patentable subject matter, it could be regarding any of the open legal questions that might arise with respect to validity. The standard for inter partes review, however, is whether there's a reasonable likelihood that the petitioner will be successful. So that's a slightly lower standard to have the proceedings instituted. So it's easier in a relative sense to have the IPR, but the scope of the IPR is much narrower than the PGR. And the issue that comes up in the Cuozzo case is laid out in section 314D. The decision to institute is final and non-appealable. And the statute says that clearly. It's a one-sentence provision in 314D, but there is now a question in the Cuozzo case as to what that means. Is that, are there any exceptions to that? The Federal Circuit said basically no, we take Congress on its face. This was meant to be a decision that's exclusively left to the PTO to whether institute these proceedings, and that's part of the structure to make this an administrative proceeding. We'll see that there are other arguments that arise, especially Judge Newman in her dissent in the Cuozzo case in the Federal Circuit would say that this is inconsistent with the nature of an IPR, which she characterizes as adjudicative. It's more like a judicial proceeding rather than administrative, and we'll get to that in a minute. Was there a question, Molly?
There is a question.
Okay. Molly?
Yes.
So there's a question that Molly's going to read to us.
Now that we have IPRs and PGRs, shouldn't,
Is that the question from last time, or somebody raised the question that sounds like that last time?
Well, it says, it just came.
Oh, just read it.
Shouldn't the defendant be required to take that route to avoid, I'm sorry, this is not, I can't read it.
I think that was the question that was raised last time when we were talking about halo and willfulness. And so I think that's an interesting question. I think that's just open. It's not the issue in the Cuozzo case, but I'll be glad to try to flag where it might be an issue as we get down the road. Okay. All right. So the first step, as I mentioned, is whether to institute the proceedings, and that's something that is a question in this case. The second step is also at issue in Cuozzo, and that is whether the grounds exist for invalidation. And this arises usually before a panel of 3 administrative law judges. And as we saw earlier, the practice is to use the broadest reasonable interpretation, and that is what's that question here. The broadest reasonable interpretation is not in the statute. Congress did not have it in the 1952 Act. It's not in the AIA. It's part of the practice of the USPTO that goes back to at least 1906. So there's some cites here for one of the oldest cases that talks about broadest reasonable interpretation, as well as a more recent case that also affirms it. So the question is whether that practice, it's not in the statute, but something that the agency here has adopted, is the correct standard to use for interpretation. So it's a 2-step process, and the question is, in Cuozzo, is both about the institution of the proceedings and this question about what the grounds exist for invalidation. And before getting into Cuozzo in a little bit more detail, I think it's worth talking about why this is such an important case and why the arguments on Monday are being closely watched. And the final opinion is going to have lots of implications for patent practice. And in order to kind of address these issues, I've looked at some statistics that the USPTO puts out, and I'm incorporating them here into my slide presentation. And so these are slides that are available online. They were published just end of last month, and give you some statistics about the Patent Trial and Appeal Board. I can give you the link, or this is pretty easy to find on the website. But it's worth talking about these statistics with respect to inter partes review, because it gives you some sense of why these are important. And so if you look at the first slide from the PTO, this is the disposition of IPR petitions that are completed to date, and this is as of March 31st of this year. And so this kind of gives you a sense of the, should I stop or? Okay, so this will give you a sense of the, we're adjusting the slides a little bit here. This will give you a sense of how these cases get disposed. At the outset, people may be familiar with the controversies over the IPR and these other types of proceedings. One prominent judge referred to these as death panels. This is where patents go to die. These statistics put that in a little bit more light in terms of what's going on. Hopefully these are fairly legible. The first is that there have been 28, about almost 3,000 petitions that have been filed. And roughly, you can sort of see the split, 50-50. In 1429 of these petitions, nothing has been instituted. In another 1,400, the trials have been instituted. And so you see, the split of this. In the cases where trials were not instituted, roughly 860 of those, so more than half, the petition was out and out denied. And then in 560 of these, you can sort of see the breakdown. 50% of those are settlements. Others are dismissals based upon procedural reasons. And the other ones were requests for advanced judgments that we can talk about that were instituted. So just looking at it from the perspective of a petition being filed, there's roughly seems to be about a 50% chance that a trial will not be instituted. That's a little bit lower in terms of the petitions being denied by an action of the USPTO rather than some decision by the parties. If you look at the ones in which the trials were instituted, yeah, I have it. The trials were instituted. You see again more than half where the trials were completed. So you have some sort of final written description. So that's the 894, and then 549 again, where there was some termination after the institution, either through the settlement, some sort of dismissal, or some other type of request for adverse judgment based upon litigation or whatnot. We'll talk about that a little bit more detail. Let's look at the 894. You have 640 of these. You had a finding that try to look at the numbers fairly closely. Let me, Molly, if you could try to flesh that out a little bit. Just yeah, that's fine. So sorry about the missing of this. You have 23% of the total petitions being found to be unpatentable. And these are 20% of the total petitions, 44% of trials instituted were found to be unpatentable, and then 72% of the ones that went to some sort of final written decision. So the difference between these percentages really has to do with the denominator. What are you comparing the unpatentability findings to in terms of whether you're looking at total petitions, trials, or final written decisions? So if you only look at final written decisions, that seems to be the one that sometimes gets looked at to call these the death penalty, or the death panel, where patents go to die. So if you look at 123 trials, you had some instituted claims were unpatentable. Again, 4%, 9%, 14% in terms of statistics. And then 131 trials where no instituted claims were found to be unpatentable. So once you do get to this stage, if you're just looking at these numbers relatively, you're still talking about sort of low percentages based upon the total number of petitions. But once you get to that stage, if you look at sort of the odds ratios, it's more likely that you're going to find something unpatentable once you get to the trial stage, once things get instituted. You can make your own judgment about whether that makes this a death panel or not, but this puts the numbers in some perspective. The basic idea behind these proceedings is to really have another shot at looking at the granted patents as to their validity. And one of the big issues, as we'll see in a few minutes, is how this relates to litigation strategy. I think the question that was posed that Molly read earlier, and I think was raised in the previous meeting we had in March, was whether there should be a requirement to bring this. And I think it's an open question as to how the decision to institute or bring, let's say, an IPR petition or not bring an IPR petition should count in terms of patent defenses and so forth. My view is that should be independent. We'll see that the statute does deal with questions of staying civil litigation and how that works. So there's a strategic component to this that's worth pointing out. But I'm not sure if there's a good argument to say that this should be required or any sort of adverse inference should be made from either instituting or filing a petition or not filing a petition. So anyway, hopefully these statistics give you some sense of this. Some other interesting statistics to look at in terms of IPR petitions terminated to date. So you have sort of 4 cylinders that are laid out that talk about the total number of claims available to be challenged. The second cylinder shows the number of claims actually challenged and not challenged. The third cylinder shows the number of claims in which trial was instituted and not instituted. And then the fourth cylinder shows the total number of claims found unpatentable in a final written decision, the number of claims canceled or disclaimed by patent owner after institution, and the number of claims remaining patentable, and so forth. So given the time constraint, I can have you look at the slide and be glad to take any questions. But again, this is useful information to have as far as how IPR petitions get filtered through the process and how the actual number of petitions, translate into actual claims that get invalidated. So to look at some other numbers from the USPTO, it's interesting to look at the impact by technology. And sorry, the slides got a little bit mixed up here in the translation, but you can see through the bar charts the yellow representing claims found unpatentable by the PTAB in a final written decision. The purple represents claims canceled or disclaimed by the patent owner, and then the checkered represents claims found patentable by PTAB in a final written decision. And if you look at the greatest impact just in terms of percentages, you see design, but there are 5 claims there. It's a small sample. If you look at some of the other areas, you see a big impact in chemical, a big impact in electrical computer science, and then biotechnology, pharma, and mechanical business methods follow accordingly. So these are kind of interesting to look at exactly the claims that have been found unpatentable in a final written decision. If you're looking at the effect on patent owner behavior, again, there are some other marginal effects on when the patent owner cancels things or disclaims patents or disclaims certain claims in a patent in the course of these proceedings. Okay, so I recommend people look at these statistics. There's lots of different ways to interpret them, but these give some perspective on whether we can view these as really IPR as something that's out to get patents or ones in which we really are trying to glean and separate the wheat from the chaff. And so this is really one of the things that's at stake. If you look at the amici in the Cuozzo case, lots from patent owners on the side of Cuozzo, which is not surprising, basically concerned with this type of proceeding, and this gives some perspective to that. But independent of these statistics, there are other implications for these administrative proceedings, and also other issues in addition to the impact on patent owners as to what the legal outcome should be, and we'll get to that in a few minutes. So one of the other sort of impacts, or why this is so important, is the litigation strategy. And so this is laid out in 35 U.S.C. section 315, and this is in the context of inter partes review, but it also comes up there's some similar provisions for post-grant reviews. So one of the things to keep in mind is that an IPR cannot be instituted if the petitioner has brought a declaratory judgment seeking patent invalidation before the filing of the IPR. So a particular petitioner has to make a choice as to whether to pursue the IPR route, if it's still available, if it's within the time frame, and or a declaratory judgment route. You have to, if you bring the declaratory judgment route, you cannot bring the IPR route at that time. This does not apply to counterclaims, so that if the petitioner is being sued for patent infringement and brings a counterclaim for patent invalidity, then in that situation, it seems from the statute that the IPR could be pursued as well. So again, this is something to look out for, and maybe the subject of future litigation as to how, whether that makes sense to treat those two situations differently. As you know, in other situations, the law did create differences between claims and counterclaims, and the court reversed course on that. The other issue to talk about is if a declaratory judgment action is brought on or after the date of the IPR petition, the civil action is automatically stayed. And so automatic stay of the civil action as the IPR petition gets reviewed. And there are 3 exceptions to the staying of the civil action. If the patent owner moves to lift the stay, if the patent owner files an infringement suit or counterclaims for infringement, or if the petitioner moves to dismiss the declaratory judgment action. So this is a very important realm to think about. It's not an issue in the Cuozzo case, but certainly would be the subject of future litigations. Already some cases that we'll talk about in a minute or so that deal with this issue. But this is also why this is such an important case, because it can affect the dynamic between going to trial or going with administrative proceeding. If, for example, the Supreme Court says that there has to be a claim construction type proceeding in the IPR, so not the broadest reasonable interpretation, that creates some sort of parity in some ways between the administrative proceeding and the court proceeding, which might affect this particular dynamic. If, however, the Supreme Court says that broadest reasonable interpretation continues, then that's going to affect this dynamic as well in terms of how petitioners go to court versus using these types of proceedings. And so there are a couple of cases that have dealt with the stay issue more broadly. And so the Federal Circuit in the virtual agility case from 2014 dealt with this issue of stay. So in that particular case, the Federal Circuit reversed the district court denial of stay of an infringement action when the PTAB review was initiated. So again, the Federal Circuit seems to be in favor of stays. So the language in this opinion was fairly strong, somewhat critical of the district court in basically not allowing the stay. If you read the pattern of this case, a little bit different than the language in the AIA regarding stays. This had to do with the initiation of an infringement action and the subsequent initiation of PTAB review under the IPR. So it's a little bit different scenario. Does not directly fall under the statute, but for matters of equity, the Federal Circuit says we don't want inconsistent judgments, or we don't want this kind of forum shopping even, or this kind of simultaneous assault on the patent owner, both within the courts and in the PTAB. So that's a case worth looking at, but it's also important to keep in mind the broader dynamics of litigation and PTABs. So that summarizes or concludes my overview. And I wanted to spend some time on this because it's good to get a sense of the landscape before we get into the details of the Cuozzo case. Molly, were there any questions or?
There's no.
Okay. All right, that's fine. Feel free, at your leisure to ask any questions you have about the material that I just went over. And then I want to move on, though, to the actual Cuozzo case. So this is the patent at issue in the Cuozzo case. Again, maybe hard to read, but you can take a look at the slides on your own. It's a speed limit indicator and method for displaying speed and the relevant speed limit. It's a patent that was granted in 2004 and was one of the first subjects of an IPR petition filed after the AIA. You can sort of get a sense of this from the figure as to what the is there a problem or no?
It's
Okay.
coming up blank on mine.
Okay.
Go ahead.
I'm not
Okay.
seeing that.
You're good, Joe.
Okay, let me just go ahead then. Hopefully people can see the slide. I'll talk about this in some more detail, but you can take a look at the patent number and the things at issue. It was awarded to the inventor, George Cuozzo in New Jersey, and then he set up the company that basically has been marketing and manufacturing and selling this. The petition was initiated by Garmin. As you can imagine, Garmin is involved with the GPS systems and the travel locator devices. And so they were challenging this on the grounds of lack of novelty under IPR and non-obviousness. And I'll get to those details in a few minutes. But lots of prior art that they cited regarding this particular patent to look at this basic issue. The particular term in terms of the claim that arose in this case was the phrase integrally attached. And so integrally attached, as you can imagine, has lots of different meanings. this particular technology, combines a speedometer with some sort of a liquid crystal color display that indicates what the local speed limit is and indicates and communicates to the driver as to whether they're above the speed limit or not. And so there are technologies that are that communicate the same sorts of information, but in different ways. And so one of the pieces of prior art would have the display of the speed limit placed upon the speedometer itself. So the speed limit, let's say for American cars, or an indicator at maybe 75 or 80, and then would have some sort of warning as to when that speed limit is being increased. The advantage, I think, of this particular invention, from my understanding of the technology, is that it allows for more variability. If you're going through a speed trap, it can respond to that information if the speed limit suddenly drops in a particular area that the driver might be going through. And so these are slight differences from some of the prior art. The argument that the petitioner was making, that Garmin was making, is that integrally attached really means that they were somehow integrated together, that they no longer had any sort of separate existence. And so this was one way in which to try to capture the prior art in terms of trying to invalidate this particular patent. The USPTO took a different view of this, and I'll talk about that in a minute in terms of how that phrase was to be interpreted under the broadest reasonable interpretation, and the Federal Circuit affirmed that. So this is the patent. This gives you some background. Only one patented issue here and about 10 pieces of prior art. Let's talk a little bit about the procedural movement and posture of this particular case before we get to some of the actual arguments and analysis. So as I mentioned, Garmin brings the IPR challenge to Cuozzo's patent before the PTAB, introducing several pieces of prior art to show the patent was invalid on grounds of lack of novelty and non-obviousness. The PTAB, during the first step of the process, finds a reasonable likelihood of success on the non-obviousness challenges for some of the claims, and denies the petition on the novelty grounds and some of the other non-obviousness challenges that Garmin raised. This then goes on to the three-judge panel of the PTAB, which then cancels three claims, 10, 14, and 17, on non-obviousness grounds. And this gets to this question about integrally attached and what its meaning is for patent validity. So the appeal from the PTAB then goes to the Federal Circuit, and that affirms over Cuozzo's appeal. They basically affirm on the decision to institute. They affirm on the broadest reasonable interpretation of the claim. They also affirm on the finding of non-obviousness, and also the ability of Cuozzo to amend his claims. I won't get into that, but I'll be glad to take some questions. The AIA allows limited grounds of amendments to claims in the IPR process, and Cuozzo's move to amend was denied because it was viewed as adding new matter to the patent and broadening the scope of the patent. So the Federal Circuit affirmed on that issue. The one point that's really interesting to get into a little bit here is that the Federal Circuit announced this decision in February of 2015. Then the case went, there was a petition to have it go en banc that was basically denied. So the case didn't go en banc, and that decision not to have the case go en banc was in July of 2015. But shortly after that decision, I think maybe a day after, the Federal Circuit withdrew its original February decision and superseded it with a new decision. It didn't change the outcome. So the outcomes were the same, the affirmance on these same issues. You had the same three-judge panel having, of course, the superseded opinion, Judges Dyke, Clevenger, and Newman. The same lineup, Dyke and Clevenger in the majority with Newman in the dissent. And so it's really interesting to see what the difference is. I tried to spend some time seeing what the differences were, and there seemed to be two major differences from what I could see. One was in just the organization of Judge Newman's dissent. And I'll talk about her dissent in a few minutes. But she basically offers a more streamlined, kind of more bullet point, I think maybe in general, maybe a clearer to understand dissent that made the points, her points more affirmatively. But there was a lot of revisions in the majority opinion regarding the rulemaking or regulation-making authority of the USPTO. And I can't go, repeat this to you line by line off the top of my head, but reading it, the court really wanted to make clear exactly what the PTO's authority was to, for example, adopt the broadest reasonable interpretation and how that relates to questions of deference to administrative agencies. So it's just interesting that they were refining that language, because that certainly will be an issue, or could potentially be an issue. I would actually say should be an issue if it's not raised before the Supreme Court in terms of how it deals with this agency, Congress, court issue regarding deference. So it's interesting to point out that the original opinion from February was superseded by another opinion in July. And it seems like the main substantive differences had to do with how the power of the USPTO as an administrative agency was portrayed. And I'll go into that in some more detail in the next couple of slides. Okay, so what are some of the issues from the Federal Circuit? This allows us to then look a bit into the Supreme Court oral argument and some other issues. So if you look at the majority opinion, basically the court looks at the statute itself. The statute makes it clear in 314D that the decision to institute is final and non-reviewable. The court doesn't second-guess Congress. With regards to any due process issues or other issues of the rights of the patent owner or of the petitioner, the Federal Circuit does talk about the availability of mandamus, and I'll have another slide of that towards the end of our discussion, because that's a fairly important one to keep in mind. The Federal Circuit hedges a little bit here to basically say they're not saying as to whether mandamus is actually allowed under the statute, but they do say if mandamus were allowed, then this is how the analysis would go. And basically, the Federal Circuit says here that even though there were some things that were non-reviewable, Garmin, the mandamus would not be available there in terms of the reviewability of this decision to institute by Cuozzo and presumably by Garmin as well. And I'll talk about that in more detail. So there is this issue about mandamus as a substitute for reviewability, or as another pathway for reviewability, but the Federal Circuit took a fairly textualist approach to say the statute means what it says. As far as the broadest reasonable interpretation, the Federal Circuit recognized that it's not in the statute, but it also recognized that it's been practice of the USPTO for over a century in examination and interferences and re-examination to adopt this broadest reasonable interpretation when looking at claims, rather than doing something else, whatever that something else might mean, a full-blown Markman hearing or some sort of narrow, maybe ordinary meaning, plain meaning type approach. As I mentioned before, the PTAB here seemed to have a mix of approaches when it adopted broadest reasonable interpretation. It did look at the plain meaning of the words, but then it looked at it in a broader context as well to understand what the claims would mean. So important to see how this would arise and how this practice comes up. This is where you see the difference then between the February opinion and the July opinion on the issue of Chevron deference. So the Chevron case, which is an administrative law case for the 1980s, very important case regarding the agency's authority to resolve ambiguities or uncertainties in a statute when it enacts its own regulations or practices. And here we need to be, I'll hedge over that a little bit because there are some interesting issues as to how Chevron would apply. But the Federal Circuit does apply Chevron here and basically does say, okay, the statute is not clear about what the interpretation should be in the context of an examination or an IPR. Therefore, the USPTO does have the authority to fill in that gap and the use of broadest reasonable interpretation seems to be a reasonable way to fill in the gap that's in the statute, hence Chevron deference. As I mentioned before, there's a lot of changes in the two opinions on this question, just about understanding the USPTO authority. So I would not be surprised if this comes up again in the context of the Supreme Court oral argument on Monday, as well as any issues in the final opinion, and frankly, in any subsequent appeals and application of this issue that arises. I just want to flag it here, and I'll try to give some more discussion of it as we proceed, but it's worth be alert to that issue. Judge Newman, as usual, wrote a very, very important and interesting opinion. Here's a dissent in Cuozzo, and it's worth emphasizing her bullet points, her points, because I think these are arguments, obviously, that Cuozzo, I think, will pick up on in the oral argument on Monday, and certainly will come up in the deliberations and in terms of the opinion of the court. The first point she makes is that post-grant proceedings, such as the IPR, are adjudicatory. They're different than something like an examination, even different than something like an interference or a re-examination. They're like mini trials. They're between the three judges, they're in front of three judges. These proceedings are ones that should be treated like adjudication and therefore are very different than what you see in other types of proceedings, or even cases where the agency is involved in actual rulemaking or the writing of regulations. As she also points out, the broadest reasonable interpretation is really an expedient for examination. We want the examination process to go smoothly and fairly efficaciously, as well as fairly quickly, and therefore the agency adopts the broadest particular interpretation on the theory that if the claims survive that, then there's a very robust or strong conclusion that, at least in terms of how you perceive the claims regarding the validity of the claims. So if the broadest interpretation is valid, then any subsequent narrowing that might occur, let's say through a Markman hearing, they might also survive as well. So it's really examination expedient, and in the context of that. And she also points out that if you're worried about the claims, though, giving some sort of public notice function. So once the claims have been granted and have been publicized, then the public gets some sense of what the metes and bounds are of the invention, or however you want to phrase that particular issue. What the invention is and how it's covered by the patent. She argues that becomes defeated by the broadest reasonable interpretation. So it's one thing before the patent claims have been publicized, and in that situation there is no public notice. I mean, the application does get published, but the claims are not granted, so it doesn't have the same legal force as once the patent is granted. Once the patent is granted, though, the public is put on notice, and then if the agency comes back and starts taking a broader interpretation, then a true interpretation, to use that language, or an accurate interpretation, then this public notice function seems to be undermined, according to Judge Newman. There's also limited opportunity to amend in an IPR, and this comes up in this case a little bit, though the particular issue is not up on appeal. And therefore, this also affects, in terms of the interpretation of the claim. If you take the broadest reasonable interpretation, it's found to be invalid, then the patent owner does not really have the opportunity to either disclaim, or doesn't have as broad an opportunity. There is some opportunity to either disclaim or to amend the claims in light of this. So she's a little bit concerned about the power this might give in terms of invalidating the claims, without also giving the patent owner some opportunity to respond. And then finally, on the issue of Chevron deference, the way she phrases it, and this is her language, is that the deference to an agency arises for implementing a statute, not changing it. And so this is kind of an interesting rhetoric here as to what does it mean to implement versus change. The statute does not talk directly about this question of claim construction. And so that issue has largely been left up to the courts and to the agency. So, what she may be meaning by changing the statute may have to do with the function as she sees it of the Patent Act and specifically of the America Invents Act. I don't think she's giving away wholeheartedly to the notion of these proceedings as ways of invalidating or giving a place for patents to die. I don't think she goes to that extreme, but she is concerned about the AIA processes, which she sees as basically streamlining the review of patents, allowing some opportunity for gleaning invalid patents from the PAC. I think she views that as maybe either enlarged or maybe upset by the broadest reasonable interpretation, as well as this question about non-reviewability of the agency. But again, it's just interesting to note here the importance of this question of deference to the agency. Certainly comes up in Judge Newman's dissent, and will also be a big issue on Monday. So let's move on, if there are no questions to this. What could we expect on Monday? As I mentioned, we'll have another webinar. We'll have one in between, but we'll definitely have another one end of June or early July once the term is over, to see how these cases actually came out, not just simply the Halo case that we talked about last time and the Cuozzo case that we're talking about now, but also the Kirstein case regarding attorney's fees. But if you look at the amici brief, I counted 33 amici briefs that were filed, 10 in favor of the USPTO, 10 were neutral, and the ones that were neutral largely were looking at this case as a procedural matter. They chimed in on the issue of this non-reviewability, as well as some chiming in on the deference to agencies. I mean, they were concerned there about how this decision might affect reviewability of other agency decisions. And so you had 10 of those that were neutral, and then 13 that were in favor of the patent owner, as I described before. They really are concerned, these 13, that this is something that's undermining the rights of patent owners. I didn't actually go back and do the search as to see whether the phrase death panel was actually used in any of these amici. But certainly that's the subtext, certainly that's the vernacular view of this, that this is where patents go to die. Is there a question, Molly?
There is.
Okay, good.
What's the purpose of a neutral brief? What does the submitter hope to gain?
The neutral brief basically is, it has partly to do with the procedure as to, which side you're filing the brief on in terms of getting permissions and so forth. So there's that procedure in terms of submitting the brief. The idea behind the neutral brief, I think maybe I'm reading too much in the question. One aspect of that question is anything truly neutral. And if you read some of the neutral briefs closely, you can sort of see, it's swaying it one way or the other. But typically the neutral brief is dealing with sort of the broader, maybe high-level issues raised by this case. As I mentioned, this question of administrative review more broadly, outside of IPRs and maybe even outside of patent law. And that's where a lot of those neutral briefs chimed in. So if there's a follow-up, please let us know. So, one of the issues that I mentioned is this issue of deference to the USPTO. People may remember this case from 7 years ago now, Tafas versus Dahl, the Federal Circuit case, which had to do with these rules that the USPTO introduced, I think about 2006, 2007, that limited the use of continuations and continuation in parts. And so that got lots of controversy, lots of administrative challenges, and eventually this went to the Federal Circuit. And the Federal Circuit basically says that there's deference to USPTO on procedural rules, but not substantive rules. And so the issue about limitations of the number of continuation applications, the Federal Circuit concluded no deference. The court basically viewed that as a substantive rule. And so this is kind of interesting. What do you mean by substance versus procedure? The reason why the court viewed this as a substantive rule is that the denial of a continuation was based upon the number that had been separately filed. So even though that might seem procedural to say you can only file, let's say, 3 continuation on parts or continuations, but the way it's framed is that if, let's say you look at the 4th continuation application, that gets denied because there were 3 that were previously filed. So that's no longer, at least according to the Federal Circuit's characterization, a pure procedural rule in terms of deadlines and so forth. It now becomes substantive in terms of why something gets denied or granted by the agency. So it's interesting to see how this is going to come up. I have not gone back to the amici brief to see how TAFIS, or if even TAFIS has been cited. I know it has been cited. I don't know how extensively. But certainly there will be some issue there about, first of all, would the court accept this distinction between procedural rules and substantive rules? That's not within Chevron, but it's possible that the Supreme Court would say that Chevron would not apply. If you look at a lot of other patent cases, the Federal Circuit adopts something called a Skidmore deference, and even the Supreme Court has hedged upon this issue as to whether Skidmore deference or Chevron deference would apply. And the difference between the two has to do with the rule-making power of the agency at issue, which then might go back to explain some of the changes between the February 2015 and July 2015 opinions from the Federal Circuit. So I expect to see something along these lines, at least the court, maybe not directly addressing TAFIS versus Dole, but at least trying to understand Chevron versus Skidmore deference and trying to understand maybe where the deference to the USPTO should apply. And if they take this distinction, procedural versus substantive, then the question is whether something like the decision whether to initiate or the broadest reasonable interpretation are procedural or substantive. On the surface, they both sound substantive to me, which means then that there probably would not be any deference, depending upon the framework, again, the court adopts. But it'd be very interesting to see from just a question of administrative law and practice, how this is going to play out. So I really, really want to signal that right now. Were there other questions, Molly? Or?
No.
Okay. So I've got 2 more slides in the remaining time that we have. And this is now looking at it a little bit more broadly. What's at stake? What are the terms of the argument? So whenever we see the Supreme Court reviewing a patent issue, whatever that issue might be, the first question is, are they trying to take the Federal Circuit to the woodshed? Right, so that's the issue that comes up in a case like Bilski regarding patentable subject matter, cases regarding non-obviousness, cases regarding prosecution history estoppel, and so forth and so on. To what extent is the Supreme Court, saying the Federal Circuit is creating too narrow rules that apply only to patents and ignoring the fact that they are a court within the federal system? There are lots of reasons why that might not come into play here. It could, but I think there doesn't seem to be any issue directly of a special rule created by the Federal Circuit. It's largely about the interpretation of the patent statute and the place of the USPTO in the scheme of patent law. So it's very interesting. I mean, maybe the Supreme Court will, say that more should happen in the USPTO, less in the Federal Circuit. That might be an indirect subtext of whatever they decide if they take on a position that's very deferential to the USPTO. On the other hand, they might, swipe at the Federal Circuit by saying there should not have been Chevron deference in a case like this. If you do take the model that the reason why the Supreme Court looks at cases is to correct the Federal Circuit, that might be an issue of correction that this court might pick up on. I do think that really it is, this is the first of its kind in terms of looking at the AIA, and the Supreme Court may have been thinking about those broader issues, but this narrower one about the Federal Circuit's power and authority might be implicit in how the court views it. There's also this question of judicial review. You see, for example, in the secondary liability cases like Comel from last term, these common law patent rules. And what I mean by that is, judge-made rules about how patent law should operate. We saw this a couple of years ago in the Stanford versus Roche case regarding assignments and ownership of patents, the court adopting a very common law approach to how they understood the Bayh-Dole Act. And so you might see that here as well in terms of looking at the reviewability question. They might find some sort of gap in the statute or find some basis in the statute to say that non-reviewability doesn't really mean non-reviewability. There's got to be some judicial review of an agency action. They might, in fashioning that, think about the protection of patent owners. If they're the ones who want to challenge the reviewability, then they, or the institution, then there might be some concern there. And in general, there might be some concern about the patent system more broadly. The initiation or the review of the decision to initiate can go both ways. Whether it's the patent owner challenging the grant of an initiation or the petitioner challenging the denial. And so there might be some consideration of the broader patent system and the way these proceedings are supposed to operate. So it'll be interesting to see if this is another tack that gets played out. So let me conclude by talking about some of the implications for practice and tech commercialization. I'll do more of this when we have our podcast, or rather our webinar in July, once we know what the court does. We have no idea what the court would do. Obviously, I can make some guesses, but these are the 4 issues to think about. Mandamus, is that going to be a possibility if the court says non-reviewability means non-reviewability? Then what's the role of mandamus, 28 U.S.C. section 1651? 3 requirements for mandamus. The Federal Circuit talks about this both in Cuozzo and in the In re Procter & Gamble case. 3 requirements have to be shown in order to have reviewability under a mandamus position. No other adequate means to obtain relief. Right to issuance of writ is clear and indisputable, and it's appropriate under the circumstances. And in the Cuozzo case, the Federal Circuit really focused on the second of these to say that it wasn't clear and indisputable that there would be some right to the issuance of the writ. In other words, some fundamental right or some other type of statutory right had been violated. You need to now think about extra care and burdens in seeking patent protection, especially the possibility that even if your patent is granted, it might have the presumption of validity in litigation, but it can be subject to these challenges, and these are just going to come more and frequently. There is another issue that's come up that's interesting that I've looked at a little bit, and that is settlement in PTAB proceedings. Many of these PTAB proceedings do result in settlement, either before the decision to initiate or after the initiation decision. And so those are kind of important as to whether those settlements might be occurring in some anti-competitive way. I kind of highlight that issue because that's of concern to me. We know, for example, in the Actavis decision from a few terms ago, the court does look at settlement and litigation, at least in the narrow context of reverse payments, fairly closely. But that case also talked about, the anti-competitive use of settlements that's worth thinking about. And then finally, even though many of the speakers, many of the audience may be involved in patent prosecution, it's important to keep in mind litigation strategy, especially the use of these IPRs in the context of litigation, the role of the stays and so forth. We're going to see a lot more litigation about litigation strategy in terms of how broad the stay is and where it applies and where it doesn't. So these are some practice pointers to keep in mind, and I'll elaborate on this once the Supreme Court tells us what their opinion is on this matter. But if there are any questions about that, feel free to email us at nysSTLC@law.syr.edu, and you can email me directly or be forwarded to me. But I look forward to hearing from you, and it was good communicating with you, and I look forward to future webinars. So, Molly, is there...
Thank you very much for the presentation. There's a lot of material, and so as people digested it, if there are questions, please feel free to forward them, and we look forward to the next webinar. Thank you.
Thank you.